is a camouflage application for stay of proceedings which this court had and dismissed. Subsequently, parties went to the Court of Appeal on the same issue. The petitioners now inform us that they willingly abandoned the application in the hope that the appeal would be heard and determined expeditiously before the lapse of the last term. The appeal is yet to be heard and determined. This court, having declined the application for stay, and there being no orders for stay of proceedings from the Court of Appeal, we are inclined to deny the application for extension of time and or stay of proceedings pending the outcome of the Court of Appeal. The decision of the Supreme Court in LSK versus AG and another, petition 4 of 2019, Supreme Court, was referred to us. The decision was rendered on 3rd of December 2019. It is distinguishable for the reason that in that matter, the Supreme Court was silently making reference to the doctrine of res judicata, whereby parallel proceedings were in different courts before the High Court, the Court of Appeal, and the Supreme Court, and raised some similar issues, which is not the case in the present matter. We restate our position that at any point in the proceedings, should we be served with an order for stay of proceedings, we will at that point down our tools. Automatically downing tools would otherwise mean that where an appeal is filed in any matter, then that ipso facto translates to stay of proceedings in a lower court, which is not the position in law. We ask ourselves, what then would be the essence of Rule 52B of the Court of Appeal rules and Order 42, Rule 6 of the Civil Procedure rules? Accordingly, for these reasons, this prayer is declined. Issue number 2, leave to amend proceedings. Given that there are petitions being mentioned before this court for the first time, and the petitioners therein did not benefit from our previous directions on amendments, we find it necessary to allow this prayer. In any case, such amendment will be in the interest of justice, and no prejudice will be suffered as the respondents, whom we note are not particularly opposed to the leave, save on the issue of time, will have an opportunity to respond. For these reasons, the application for leave to amend is hereby allowed. Issue number 3, reconsolidation of petitions. We have considered the proposal and we find it plausible as it will aid in management of the numerous petitions before the court. Final orders and disposition. In the end, the following final orders do hereby issue. 1, the application seeking to extend time is hereby disallowed. 2, leave is hereby granted to the petitioners to amend and or further amend their petitions, which shall be filed and served within 14 days from today. Upon service, the respondents and interested parties shall be at liberty to amend and or further amend their responses, which shall be filed and served within 14 days from the date of service. C, all petitions before the court, i.e. under cohort 1, cohort 2, and the petitions being mentioned today, we have named them. The petition being mentioned today for the first time, we have named them, are hereby reconsolidated into one petition. Petition number E, 565 of 2024, shall be the lead file. All filings henceforth shall be made in that file. D, this court shall accordingly issue the manner in which all parties shall appear by close of business day, 27th of January, 2025. For the avoidance of doubt, any petition filed or referred to this bench after today shall be dealt with after the hearing and determination of the reconsolidated petitions. Compliance mentioned and for further orders shall be on 27th of February 2025 at 2 p.m. This ruling will be available on CTS by close of business day, Friday, 24th January 2025. The ruling will be uploaded in the lead file. That is the ruling of this bench.
File an application to review that ruling on account of error apparent on the face of the record. The fact is, no.
Mr. Dudley, you don't need leave to file for review. You don't need leave.
We have made our ruling. You can deal with that ruling procedurally. It will be made, typed, and put on CTS by end of business day tomorrow.